Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I have the lucky ability to share a bit of a happy story, a good news story. And it's related to a story I covered previously, which hopefully I'll be able to link here. What happened there was that a woman was charged and convicted after a guilty plea of breaching a publication ban. Now, the publication ban here was with respect to a sexual assault trial where she was the victim. Her ex-husband was convicted, and so as a result of that, they put in a publication ban. That publication ban is to protect her. However, she shared some details apparently with some of her friends online, sort of a support network, and ultimately they came back and they charged her with breaching this publication ban. The person who complained that she was breaching the publication ban was her ex-husband, the guy who was convicted of the sexual assault against her. So, when you think of who that publication ban is there to protect, it's not him. Like, they're not there trying to protect the guy who's convicted of a sexual assault. It's actually her. But instead, they decided to turn around and go after her for that. As a result of the conviction, she was forced to pay a $2,000 fine plus a $600 victim fine surcharge. Can you imagine how much of a kick in the teeth that is, that you're having to pay a victim fine surcharge relating to your own victimization on a serious sexual offense? Yeah. Anyway, she appealed that, and quite properly. I was saying when I first covered it, I hope she appeals, and she has. And now that appeal has been granted as a result of the Crown consenting to the appeal, which means that the Crown got up in court and said, we agree that this appeal should be allowed, and, please throw this out. Now, the reason why the Crown consented to the appeal is not the reason you might be thinking, because the reason I might have thought is, hey, this result is kind of monstrous and it should be thrown out. That's not why they consented. The basis that was provided in court is that they said, listen, there's a legal technicality here, which is that she pled to the wrong section number. So, that is a quite proper reason to throw this out, but I also think it is maybe not the best reason. I think this was a good opportunity for the Crown to take a stand and say, listen, we're going to stand up for victims of sexual assault. And that's not what they did. I like that they gave this woman the proper result. She's going to get her money back, the $2,000 plus this $600. She's not going to have a criminal record. All of that is excellent. I can't argue with the results here. But life doesn't always give you an opportunity to stand up for what you believe in. And here, life handed that to the Crown's office, and I kind of feel like maybe they should have run with that opportunity, because I kind of feel like the Crown at least should be saying, hey, listen, we stand for sexual assault victims. Missed opportunity, I guess, is the way I will describe that. So this woman's lawyer is a Robin Parker, and fantastic work. I cannot commend this enough. This was a just cause. This was a righteous cause, and she took it up and carried the ball across the goal line. So excellent work on her behalf, on her part. I really just can't say enough for that. I am really thrilled to see that she was able to do what she did here. I think that this case really calls out for a couple of things. First, I hope that this is causing some soul searching at the Crown's office and going, guys, let's make sure this never happens again. This was a big mistake and it blew up in our face. But even if it doesn't blow up on our face, we shouldn't be making this mistake again in future. Please think about this a little more closely when you're reviewing your files and deciding if you want to proceed. This is also a great example of a situation that really calls for some legislative reform, because this is supposed to be a shield for sexual assault victims. It's supposed to be something that protects them. It's not supposed to be a weapon for the guy who was convicted of the sexual assault to use against the victim. That should never be the case. The law is not supposed to be something that protects the aggressor against the victim. So I would love to see this changed. I would love to see that a publication ban was something that that perhaps the victim can waive unilaterally, if they go into court and say, I don't want this, that it shall be lifted, and possibly something that they can waive through conduct, in the sense of if they go and share this, then the argument is, listen, they've decided that they don't want the publication ban because they've acted in this way, but not to say, hey, they need to be punished. Now, of course, there would be some wrinkles to that. There are some places where you would have to exercise a bit of caution or a bit of thought. And one of those would be in a situation where there's multiple complainants, because you might, for instance, have multiple victims, and you don't want it that one of them can come forward and say, I want to share the story, when the other one is saying, listen, no, I need this protection. I need to be shielded. I can't stand up to the weight of public scrutiny. So this was actually set to be a much bigger proceeding. There was a whole lot of groups, I understand, that were kind of lining up to say, we want to make this into a big hearing. There were victim groups who said, hey, we want to have our say in this. There were also media groups who said, we want to have our say because this limits the ability of people to go and report to the media and say, hey, I want you to tell my story. So ultimately, none of that is going to happen. We're not going to get any sort of real rulings on this, but I like the outcome. I mean, as much as there's all sorts of things I might have wished to see on this, I'm still happy that, you can't forget the person involved for the principles. And there's all sorts of principled reasons why I would have loved to see this become a fight. But, you don't want to forget that there's an actual real woman involved in this. And she didn't need this criminal record. She was going to be going into a custody battle. And it doesn't need to be a situation where it's like, oh, both of them now have a criminal record. No, that is exactly the wrong thing there. Anyway, shorter video, but I just really wanted to share this one. I saw this. I was thrilled to see the outcome. If you enjoyed this, please like this video. Please share it with your friends. Please subscribe to see more content. I also want to thank my Patreon supporters. There will be a link to the Patreon below if you want to join up. At the $50 level, Jason Elliott, D. Moe, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, CCFR, BCAMF.org, Andrew Schaefer, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Adam Meester. As I also want to thank all of you at the $10 level who will be in the crawl immediately following. Thank you once again for watching. I hope this has armed you with knowledge. I will get to the case of the Queen and Senior. There's more to that to come, but there's something that's sort of come up as a question that's been asked a couple of times, and so I want to address that. That'll be for tomorrow. It's with relation to Bill C-21, which I know I've talked about a lot, but I'm not done with. So I'm going to talk about a particularly interesting wrinkle and a particularly interesting way that C-21 can go wrong. And this one is really one that affects soldiers. So stay tuned. That'll be coming out, I hope, tomorrow, but we'll see how things go. Anyway, thank you for watching. I hope this has armed you with knowledge.